You can go for it for 1 second, Your Honor. Sorry.
Well, stuff going on then.
Other materials. Good morning, may it please the court. I'm the name of the indulgence. There's 5 minutes rebuttal. Court should reverse and remand in this Eagle progeny case for at least 3 reasons. First, trial court erred in instructing the jury in both phase 1 and phase 2. Use the damages. Second, the trial court erred in permitting plaintiff's expert, Dr. Stowaway, to give highly speculative testimony without examination, and to do so for the sole purpose of disparaging. And then third, the trial court erred in preventing Reynolds from cross-examining the expert things concerning his reliance worksheet containing falsehoods, and then instructing the jury in a way that again disparaged Reynolds. And to start with the issue of punitive damages. During both phase 1 and phase 2, bifurcated trial, the trial court told the jury that they could impose punitive damages based on the quote misconduct. Reynolds couldn't. We have cited cases from around the country, recognizing that it is impermissible to impose punitive damages on the kind of co-conspirators, folks on its own conduct. My friend has not grappled with those, they're out there. The court doesn't have to look outside of Florida. We have the Alexander case. So Alexander was an Eagle progeny case. The defendant is held liable for conspiracy. And then the defendant argued on appeal, punitive award against it was impermissibly based on conspirators. And the 3rd district rejected that, applying settlement with
The Laureate case.
exactly, Lord Harvey Alexander. And the 3rd district rejected that argument. It noted that the trial court, keeping with the widespread rule, had instructed the jury they could only impose punitive damages for harm that the defendant caused and the defendant's own conduct. And so the case fundamentally rests on that rule. My friend has an alternative view. It's based on reading the opinion selectively in that context. And so the key point about the opinion is it proceeds in 2 parts. First, you have that instructional. It's setting out the legal. And then you have a lengthy discussion of the evidence. So what the court is saying is that working within the proper legal framework, the evidence supported, the evidence of Boulevard's own misconduct supported the punitive award that was given in that case.
When the jury instructions were approved by both sides, right?
In this case?
Yeah.
No, we had a dispute about this. So Reynolds,
It was ultimately given over your objection.
yes, it was given over our objection. Absolutely. And my friend, aside from the 2 issues of argument, there has been no claim waiver. And I'll get to the 2 issues in a minute. But Reynolds put forward an instruction that said, affirmatively, you have to look at the defendant's misconduct. So ask whether the defendant's misconduct met the expertise. And my friend proposed an instruction that said, ask whether the defendant's misconduct or the misconduct of co-conspirators met requiring expertise. The trial court ultimately landed on my friend's version over our objection, with the addition of the language in the further. So you wound up with an instruction.
Well, the conspiracy is that equal to shooting the independent court of another.
That is true.
And that's what the judge was going by. That's what the pivotal key, the instruction.
That is correct. We're not disputing the general rule of conspiracy liability. Our point is that the punitive damages are part of it. That they, both as a matter of case law and precedent, also as a matter of
We have to have
policy.
some sort of compensatory if we get trial on punitive, correct?
That's certainly true, Your Honor. That's certainly true. And you're not fighting. My friend has many cases about vicarious liability for damages with conspiracy. That's not a dispute. The dispute is just about punitive damages. All those cases we're citing, including like the Laughlin case or the Berlin case at the federal system, are saying, look, punitive damages are and Alexander applied that widespread rule, and it focused throughout on Warlord's own conduct. And I think the closing quote, I mean, it mentioned Warlord 25 times in the relevant part of the opinion by name. It makes them the key actor in every bit of conduct.
Did the verdict form differentiate which count was awarded?
Yeah, I think so.
Damages? Yeah.
It did not, and that's a true issue.
Isn't that problematic for your argument?
Absolutely not, Your Honor. So there's three reasons the true issue will. One is that it has been obviated by special standards. The Supreme Court adopted the special promissory standard, no law that the true issue does not apply. And it's the reason is that the burdens are different. So special assumes that an error is harmful, and so it falls on the beneficiary of the error to show that there's no reason, possibility that it contributed further. The true issue rule presumes that errors are harmless unless you break them out of the verdict form and show that they in fact did the work in the verdict. And so they rest on fundamentally different premises, and the true issue will therefore be there. But the court doesn't need to reach that.
Okay, let me go back and I have a question. I'm on the verdict form. And I know you had said that there was preservation as far as the conspiracy language in the jury instruction. Was there any objection to the verdict form?
No, so the verdict form did not break out the claims. We did not fight the verdict form. We should for.
Okay, I just wanted to know if there was an objection to it not being broken out.
No, there was not. But that's tuition rule just doesn't apply here for the reason I've already given. But also because this court's recent decision in Twiggen. We submitted this as a second supplemental authority. And this court said, and I'm paraphrasing, but it's a close paraphrase. Tuition rule does not apply the issue of punitive damages. And so that is a very recent decision from this court recognizing it. I'll add the third reason the tuition rule doesn't apply is because that holding is compelled by first principle. So the Supreme Court has said that the tuition rule is just not going to apply. So the Grigsby Tomlin case held that you're not going to apply the rule if the issue is an error with respect to one element claim. And in the Abonado case, when here, the court held that the tuition rule does not apply when the error on that theory and then the other things that could have supported the award have different measures of damages. And so that's what this court was doing in Twiggen. And the reason is this: if you make an error with respect to the quantum and type, what conduct you were doing the punitive analysis for, you are fundamentally changing the measure of damages because you're changing what's being punished and deterred. And that's why this court gets straight to special in Twiggen, because like in Abonado, the error in question changed the theoretical thing that the payment was based on. And so the court should reach the merits of the issue. I've explained Alexander as something. I will add that the traditional widespread rule in all the cases we've cited makes sense as a policy matter for two reasons. One, there is just the fact that punitive damages under both federal and Florida law are limited to only two things: punishment and deterrence. And as the Ross case out of the Louisiana Supreme Court made clear, that is a highly individualized inquiry that requires you to look at the not. And then two, the U.S. Supreme Court has said you need safeguards that may result in arbitrary and punishment. In that in the instructional context, in that substantively, and certainly imposing punitive damages based on co-conspirator misconduct creates both of those rules. We add in co-conspirator misconduct and creating the possibility of a very large award, and more to the point, in cases like State Farm and Campbell, we're creating the risk of overlapping. Why? Because every single member of that conspiracy can be held liable for punitive damages for everybody else. So everybody's being double taken. And so that would violate overlapping punishments. That just underscores why the traditional rule makes a lot of sense. I'll note that my friend has cited no cases contrary.
Does it make any difference that in Deacon that their verdict form listed the separate amount for punitive damages?
You talking about Rickman? I'm sorry, I'm just making
Yeah,
sure.
Wigman,
Okay, I'm going to try to correct. I just want to make sure I was addressing this. No, because that only was with respect. Punitives are always treated as punitive entitlement questions separated out. And then in these single cases, these complicated cases, you then go to phase 2, in which you get one lump sum of punitive damages. I've never seen it work. So again, the merits are before the board. My friend decided no precedent contrary should reach the merits. I will address briefly the harmless error argument my friend has put forward. My friend doesn't address the governing standard. It's special and it's doxable when this court says special applies to instructional error. And what that means is the beneficiary of the error, the plaintiff in this case, has to show there's no reasonable possibility of error. That showing can't possibly be made, one of which is just common sense. You've got a case chock full, as my friend's appellate brief makes clear, of evidence of co-conspirator conduct. You've told the jury that they should consider that evidence and award punitive damages. Certainly, there's a reasonable possibility that they then make that patients. And then 2, the extent the court had any doubts about that, there's actually a presumption juries follow their instructions. And so it stands to reason that a jury told to consider co-conspirator misconduct more. I do want to speak briefly to the second and third issues we raised. And I want to flag very quickly that they should be considered together because they have a multiplier. This relates to Dr. Soloway, Cummings, and the problem is that a theme was created at trial that Reynolds counsel, based on these errors, was disingenuous, misrepresenting that.
Getting back to 60,000.
But that's one of them, and Dr. Cummings is the other.
They raised $60,000. The Reynolds opening statement.
It wasn't Reynolds opening
They
statement.
could have been objected to by the fund. Now you're complaining that taken out of context, taken too far, use of nefarious conduct.
Yes, but I would add, subsequently, there was no nefarious conduct. So we received medical records that were available. And Reynolds counsel said as one, I'm quoting, example, in quotes, and then quote, of what the evidence of damages in this case would show was the $60,000 in medical expenses. That was a comment on what the evidence would show. That is what opening statements. And so,
But then it was raised again by Reynolds in their closing statement.
so at that
Well,
point,
they led with the 60, they ended with the 60, and they complained about the 60.
they did not end with a 60, Your Honor. They ended with a statement about stipulation of 2,000.
Where did that number come from?
We got a stipulation sort of mid-trial after the Dr. Soloway event went down. That was when we reviewed the procedure. But that can't paper over the error here for a
And they
error.
waived the claim for reimbursement.
They did, but to the extent the concern there is harmlessness, the harm is not limited to the claim of reimbursement. It's the disparagement of counsel.
So here's my question. Ugly is in the eye of the beholder. Doesn't seem like the trial judge took this as ugly. Took it in stride, it was kind of irrelevant. Who cares if the medical bills will? And everybody knows it's more than 60,000 for this procedure anyway. Didn't seem like they directed their anger and animosity, misunderstanding towards counsel.
Your Honor, frankly, this was an abuse of discretion. There's no way to read this record but that it was disparagement of counsel. And plaintiff said that's what he did. He said it was to show that what Reynolds said was not even possible. I'll add about the stipulation. Apparently, they can only get agreement for 14,000. Dr. Soloway's testimony was that the total medical care would be many, many more than 60,000. And so even that meager stipulation, in a purely formal sense, could not cover the harm that was caused.
What was the time period that these bills?
I can say it was many years. He got it.
So most people don't have their bills over many, many years. So that would have been a problem, which burns on them. So that's probably why they abandoned the claim.
Your Honor, respectively, no. They kept that claim in the case until Dr. Soloway gave his testimony and then promptly outside of the court withdrew it. So this wasn't some like assessment that we decided we don't want to press this claim because it ruins our case. This was keeping the claim in the case to have a quote to the spirit of counsel and then withdrawing it by emailing counsel outside of court. And so that heightens the disparagement, lesser disparagement in Florida civil.
Was the curative instruction thought?
No, Your Honor, by the time the disparagement became clear, the ship had already sailed. And so we got the stipulation to kind of try to make lemonade out of lemons frankly unsuccessful. Everybody knows by the time you swing the back foot. I would add that Dr. Cummings, very briefly, Reynolds should have been allowed to cross-examine him with his reliance on the worksheets. I won't belabor that point unless the court has questions other than the point the state farm.
You're down to 5 minutes, by the way. So
I understand, Your Honor.
keep going.
I will very, very briefly. So I don't belabor that point other than the point the state farm and say we should have been entitled to a full inquiry. I do want to add that the court's instruction telling the jury that Reynolds had acted quote, totally improperly in acting about the worksheet, and that Reynolds' statement was unsupported by the evidence was doubly erroneous. It was not only an improper comment on the evidence, because the evidence did support the idea that he, Mr. Woodcastle, had an advantage of litigation. Because not only did he submit under penalty of perjury his last report, because common sense, he thought he would gain. He actually had a claim for lost wages that he went under entertaining, and that's in this amended worksheet. And so that confirms that the type of thing this was relevant to was in the case of the kind of lies. And more to the point, these are the kind of lies that make. So in closing, I will add that not only was it improper comment against, it was again disparaging. In Simmons, which we started in our brief, and in Seaboard Coastline, lesser disparagement required a new trial. Certainly in this case, we would have the two disparagements together and we consider together both in prejudicial error analysis and in as independent errors, a new trial.
Just so that I'm clear, the amended worksheet had his misstatements about his education.
No, not the amended worksheets he was withdrawing.
Okay, the amended worksheet wages.
And the first worksheet said undetermined. He was clearly entertaining the idea of a lost wages.
Just the planning submitted the second, which was amended, it had lost wages, but it had the correct history.
That is correct, Your Honor. During the first one where he told the lies, he was still undecided. I will remember.
You got a little, I'll just say 3 minutes.
Thank you, Your Honor.
And yes, my name is Celine Humphreys. I represent the Appalachian Families. Most of the argument that you just heard was directed to community damage insurance. We did cite Alexander. Alexander does not support the defense. Specifically, Alexander was a different issue. Alexander, that is the appellate court at the first of fraud for the underlying conduct. So the argument on appeal that the court was considering is whether or not the evidence that occurred. Keep in mind, fraud is fraudulent concealment, but it's also the conspiracy to commit fraudulent concealment. So the issue that the third district was addressing was not what is a proper jury instruction. It was this concern that the punitive damages of the jury was improperly affected by consideration of evidence that related to one of the two fraud counts. So the two cases, this case and Alexander, go hand in hand, and that they're both talking about the legal issue of what may a jury consider when determining punitive damages. Alexander does not address what the proper jury instructions should be. I say that to give context to you. So when the court is looking at R.J. Reynolds, excuse me, it was not R.J. Reynolds, the defendants are regarding whether or not a jury may consider the conduct of co-conspirators in determining whether to award punitives and how much, the court said no, and it said so for two reasons. The first one was simply a practical. In that case, that judge, based on jury instructions proposed by those parties, including the plaintiff, I don't know. There, the jury was instructed only to consider the conduct of the defendant. So to the extent that the Alexander decision cites a jury instruction differently, as it is not a holding as to what is a viable or permissible jury instruction, simply the practical of why the defendants are being failed. But the bulk of the decision addressed the legal issue. The bulk of the decision said, and you're wrong, because here, because we have conspiracy counts, conspiracy to commit fraud, because this jury hears of the acts of other defendants, deciding that underlying cause of action, that same evidence may be considered deciding punitive damages. It says so on 2 pages, 79, 81, both of which I believe. So that's Florida's precedent that is spoken on the issue. I've also provided this court with other law supporting my position. First is vote right. Vote right is a case I handled at this court, and the decision issued by Judge Silverman came affirming a verdict against one of these cigarette companies when the only cause of action that that cigarette company was found liable for was conspiracy. So in that case, there was a defendant that was not held liable for negligence, which is direct conduct, not held liable for strict liability, which is direct conduct, and not held liable for fraud. The only basis for that one cigarette company to be liable was on a conspiracy. And this court rejected the corresponding request to invalidate punitive damages. So although not the square legal issue that you're hearing today, this court has acknowledged the circumstance. And I also provided you with many decisions in the Emo litigation. So that's one thing that's interesting about the Emo Property litigation. In many respects, these are the same cases being argued over in the trial courts and on appeal. The differences relate to whether or not a particular person was convicted, how many years they smoked, what disease they had, but the legal issues otherwise not tied to a person repeat over and over. And so in the Emo litigation, you have in the many decisions that are reviewing whether or not a punitive award is excessive, when the courts have found that a punitive award is not excessive, they summarize the evidence, they summarize the evidence. It's consistent reading. And then you also have the fact that some courts have already considered this issue. I was only able to find 2. RJR is a party in most of these appeals and works with the other defendants. They would know more. But I did find Lambert, judgment to you on. This very issue, very argument was presented to this court. And it was unsuccessful there. Also unsuccessful in the first district court of appeal in Bush. And so, for all of those reasons, their argument just beyond right to the merits, I did want to mention this because I can't resist it, the argument about the standard jury instructions. Standard jury instructions are not written to cover every single circumstance. Standard jury instructions are to cover the more typical circumstance so parties can use them more readily. And then parties are under an obligation to change the standards when required by the facts. We're very fortunate that civil conspiracy is not common. So the fact that the standard jury instruction doesn't include civil conspiracy and co-conspirators is of no moment mystification. And another way of saying that is, if you look at the jury instruction given here, there's actually 2 other groups that RJR was held, that the jury was told to look to. It was told to look to, obviously, RJR's conduct, the co-conspirators, but also RJR's predecessors. None of the standards either, and RJR didn't object to it. And that leads to one final point. This is one of those notions that's, I won't say it's moot, but at this point, at the point of the trial, all of the conspirators that are talked about in the Emo decision, many of them, RJR has purchased. They come under the predecessor. So, only company left now is Morris. Also, really what the jury heard about when hearing about co-conspirators was the fact of these industry organizations that were created by RJR. And it's now companies that are owned and Philip Morris. And the evidence about that is that RJR, and RJR was the most involved, one of the most involved in all of this, or the most involved, had its own corporate officers running them. So, for all of these reasons, there's a practical reason as well that this I heard your questions on the medical expenses issue and on Dr. Cummings. Those are the 2 evidentiary arguments that I in detail in my brief, point by point, explain why those arguments fail, separating them out, and explaining that essentially all of the arguments are vague. Is there anything in particular on those abuse of discretion issues that the court would like me to address?
They raised the issue, and I thought they closed with it, but they didn't close with it. They highlighted an issue, they complained that the issue teach is crime.
Yes.
And accuse them of various conduct. And my comment was that the record could be read possibly either way. But if it can be read one way that helps the appeal, one way that doesn't, you favor, go to the one that favors the trial judge.
Right, because the standard of abuse of discretion is injured Vargas to do something that is arbitrary, fanciful, another.
It's arbitrary, and that would be the argument.
That would be their argument. So I'll take a few moments to address that. Really, when you break out this issue, there's three different points. First is the question of relevance, and that's what RJ argues on.
And that could have been objected to by plaintiff's counsel at the very beginning. Because you don't normally bring up evidence that you don't intend on showing, but you assume the plaintiff's going to show their case in chief and then object to it when it comes in.
Well, one thing you'll notice in this record, when you read the whole record, plaintiffs did not object very much. And so our approach is to basically object if we're responsible. We don't want, we want to reduce. Yeah, right, and professionalism, and we also want to reduce the opportunities for appellate issues. And so we, to call the sports term, we play a defense game. And so the fact that we didn't object at that moment didn't mean that we agreed with it. And then what we realized as we thought about it is how they said it. They did not express it as a medical expense issue. Think of all the court action where parties are fussing over medical expenses. You're going to hear stuff like that treatment wasn't necessary, that charge was irrelevant.
Well, they said that that's a substantial amount of money.
And you know what? That ties to something completely different. And that's the case law gave the court, that it is very permissible for parties to argue to a jury what the pain and suffering should be based on how much medical treatment was received. And so defendants can and do say, medical bills were only X amount, the pain and suffering, this crazy amounts of pain is what was asked for. That is the type of argument. That is the comment. Never at any time in this opening comment or in closing did they climb in to address a medical expenses claim. This isn't the kind of comment that would pertain to it. And so what we realized at first, we're like, well, if he hardly said anything, he's really not addressing medical expenses. And then we realized, oh my gosh, this ties into pain and suffering. He said the word substantial, because pain and suffering that we were referring to at Ireland, we used the word substantial. Remember, this opening comment specifically took the jury back and said, ladies and gentlemen, you remember plaintiff's counsel on Waudire talking about substantial damages, and then defense counsel connected that to medical expenses. So we realized we have to address the number because we're only questioning pain and suffering. We can't let this jury think that it was 27 years, 27 years of medical care involving many surgeries, significant hospitalization, infections, and complications cost only $60,000.
So, then you said Dr. Soloway was that
Yes, sir.
all really good.
Oh, no. That is what we focus on, and I probably left you that part in the brief. Dr. Soloway was an expert called to explain to the jury all of the harm that had befallen us because of the bladder, all the surgery. It is not for this issue, it is to explain the treatment. No, he was asked very little about the cost, so let me say that better. He was already a witness, he had already been deposed on the fact that he was going to explain and tell the jury, because Mr. Burkowski had smoked for so many years, he contracted bladder cancer, and this is the treatment and experience this man has had for all of his time. So when we then turned to the jury and talked to pain and suffering, we based that on the past experience of those 27 years, part of which had been described medically by Dr. Soloway. Because he was already scheduled to present this expert opinion, and that's what he was disclosed to. We then asked him this one point, and the questions were extremely truncated. Don't even cover 2 pages of the trial transcript. And it was simply based on your review, your experience, based on your background, you're a logic oncologist for 50 years, based on your understanding of the kind of treatment and hospitals and billing in that 50-year experience, and based on your knowledge of this man's history that you had to know to get all this other testimony he gave us, can you tell us
would 27 years of medical care cost $60,000? And his answer was no. It would have been many, many, many times. That's it. That's all we asked. And we never repeated it again. We never mentioned this to the jury, even when the defense pointedly used a stipulation against us in closing. And use that stipulation, first of all, telling the jury about out-of-court conversations, suggesting to the jury that we had conceded error, challenging us and accusing us asking Dr. Throwaway these questions improperly. We still stayed on it. So the only thing on our side that we did was each and a half into that, and that's including objections. The actual testimony was this. That's all we did. We never even once in the whole trial mentioned medical expenses. And then I'll go ahead and go to the assumption. Their assumption that the second point is that all of this was to denigrate. So that is based on 3 flawed assumptions. The first flawed assumption is the only reason we would have talked about any of this is if we had a medical expenses. That's wrong for the reasons I just said. This kind of testimony is also relevant when arguing in suffering. I provided the court many decisions where medical expenses evidence are admitted in cases where there is no medical expense claim because juries can look to the amount of the bills and trying to figure out what to assess human suffering. So that assumption is wrong. The other assumption is implicitly, anytime a plaintiff responds to an allegation or statement by the defense, it must be attempted. But if a defendant is going to take on the position of making a factual representation, there's nothing wrong, even in criminal cases, with the plaintiff or the state responding to the factual assertion. So that assumption underpinning this notion that we were denigrating them on things. And then the third assumption is based solely, and this is really the only thing they can point to, is the fact that we abandoned our claim for medical expenses. And as they state, I'm the one who abandoned it. I was out of court with their appellate counsel out of court. We're constantly emailing back and forth about jury instructions, what are we doing or not, and trying to resolve as many things as possible before 2 of us, not the trial lawyers, get to court to talk about the jury instruction. And I told them we were not pursuing the medical expenses. Parties abandon claims all the time, all the time. And Engle plaintiffs almost never pursue medical expenses. So for them, for that one act to assume that this was some sort of intentional attempt to denigrate them in front of counsel, it fails. It's also illogical. So consider what their argument actually is. Their argument is, well, if you hadn't pled a medical expenses claim, we wouldn't have misrepresented it on the medical expenses. Whether we had a claim or not is irrelevant to the fact that they told the jury in very clear terms, ladies and gentlemen, the bills here are only $60,000. Or they said about almost $60,000. And in all of this discussion for Judge Barbas, they never disagreed that the overwhelming majority of medical bills were not available. They knew that. So it's illogical and it's unfounded. And there is, and frankly, when you are going back to the standard of review, you are reviewing whether Judge Barbas abused his discretion, and the only argument is based on inferences. Inferences are almost never successful in such a standard. So the only other issue is the one regarding Dr. Cummings. You didn't ask that many questions, and there wasn't much comment. Would the court like me to address the issue of possibilities? I really appreciate your time. Thank you very much.
Right, so you round up to 3 minutes.
Just a few points. My friend suggested that Alexander didn't address this legal issue. I did address the legal rule. You don't spend 9 paragraphs applying a legal rule that you were just accepting for the sake of argument, which is what this court did in Alexander. And the fact that it wasn't an instruction case is irrelevant because instructions are based on legal rules that are applied in cases. Alexander was developing and applying a legal rule. My friend mentioned boat rights. At R 79232, our friend acknowledged that boat right was not on point. And then to run down our cases, and every one of them, it stands at most for the idea that punitive damages can be based on a conspiracy claim. That is something we are not disputing. And most of them actually say expressly that they're looking at, quote, the defendant's own conduct. And that's in the case of DCA 4 and the Burt case under the Pennsylvania Superior Court that my friend cited. My friend mentions the Bush case and the Lambert case. I was surprised to hear that those are PCAs. I would just respectfully refer to the Schlesinger case, which the fourth DCA said that it's improper to cite PCAs. The rule makes good sense. Both of those cases had waiver arguments that my friend raised, and so we have no idea what they stand. Anyway, my friend mentioned that there's only one co-conspirator left, Philip Morris, but plaintiffs in these cases leverage Philip Morris evidence a great deal. In this case, they emphasize a Philip Morris document referring to smokers as, quote, rats in a cage, in reference to like a Pavlovian response, and the idea of electric shocks on animals demonstrating the powerful urge to smoke. Internal Philip Morris document, nothing to do with Reynolds, and indicative of the broader kind of evidence, including ads of co-conspirator conduct that come in. As long as that evidence is in, the jury's told to consider co-conspirator conduct, there's a real possibility the error contributed to the verdict, and that's again the special standard my friend didn't confront. Finally, the pain and suffering idea that medical bills are related, I'll be very, very brief. We cited the Sablatny case that points up that that is a logical connection. You can imagine a very simple surgery, like setting a broken leg and avoid pain and suffering. You can imagine a very expensive surgery, like a cosmetic one. It does nothing.
Now to 19 seconds.
Thank you, Your Honor. Last point, the idea that that was relevant to pain and suffering. The court can scan the sidebar transcript, and my friend never once suggested that this was a matter of pain and suffering damages. I see that I'm out of time unless
Good. There's one second left. Thank you. Have a great day. Thanks very much. Keep going. Let's get the Pinellas Suncoast Transit case versus
May it please the court, counsel, my name is Jeffrey Jensen. I represent the appellant, Pinellas Suncoast Transit Authority. In this case, the parties agreed that reversible error occurred. What is disagreed is what the court should do about it. Should the court agree that there was reversible error? And that issue is the